I honestly believe this has become a battle between one of the most prestigious law firms in the crypto industry out of New York and a up-and-coming fiery legal team for the Securities and Exchange Commission representing we the people. Hi folks, my name is Troy Dooley. I'm the Beachside CEO. I need to read a disclaimer here real quick before we get into this. This has been prepared by my attorney. It says, due to my SEC settlement in the Zeke Rewards case in 2013, which includes me personally as well as my company, Deep South Companies, my attorney Kevin Thompson of the law firm Burton Thompson in Nashville, Tennessee, has drafted the following disclaimer before I begin. I want to make it clear that I am not affiliated in any capacity with digital licensing, aka the D.E.B.T, aka the D.E.B.T Counsel, or any of the other defendants or relief defendants. Not as an employee, not as a consultant, not as an advisor. This video is for informational purposes only and should not be construed as any endorsement of the businesses or the business models questioned in the SEC complaint. I am not in any position to verify or refute any claims that anyone may make in the comments below, now, or in the future. So I wanted to lay that out there for you real quick. I also want to bring you fast up to date so that you guys know what's going on. Number one, the SEC or the defendants have filed a motion. This is called a motion to dissolve the TRO and modify the temporary receiver order. The SEC has until end of business today to file an opposition to the request for the TRO to be thrown out. The D.E.B.T Counsel then has until Monday, the 2nd of October to respond. And then the judge is going to hear this on October 6th. So that brings you up to date on that part. If you guys want to leave now, feel free to leave. But if you stick, listen, why is it that the D.E.B.T Counsel is now asking for this? It says, we believe it needs to be resolved. The temporary restraining order, including the asset freeze originally issued in the ex parte on the 28th and the last renewed on August 29th, and to modify the temporary receiver issued on the 28th. That's what they're asking for. And the reason they are is they say the SEC got this case wrong, badly wrong. This is not a fraud case. The SEC claims the defendants made outrageous misrepresentation to investors in connection with the defendant Digital Licensing, Inc., the sale of their Node software, and engaged in sham businesses so the defendant could further line their pockets at the expense of the investors. The narrative, common in security fraud cases, does not fit here. Had the SEC done a full and fair investigation before rushing headlong to pursue the ex parte temporary restraining order on the afternoon of Friday, February 28th, it would have discovered the truth. There are real people operating businesses associated with the Node software licensing sales at issue, with real people working for those businesses, and that appropriate disclosures, not misrepresentation, were made for those businesses. Indeed, as shown below, the SEC presented insignificant evidence, which included inadmissible hearsay based on speculations, to warrant a TRO under the Supreme Court and 10th Circuit case law. But what makes this case particularly unusual and worthy of further immediate intervention by this court, and we do not say this lightly, is the SEC improperly obtained the ex parte by misrepresenting the exigency with respect to the defendants and the relief defendants. The SEC also requested appointment of a self-selected receiver from Florida who has grossly mismanaged the D.E.B.T's valuable assets in this case while charging exorbitant rates. The transcript of July 28, 2023, the ex parte TRO hearing, which was obtained by defendants on August 25th, almost a month later, shows the SEC confronted a court focused on the enormous harm that can be inflicted by the ex parte and correctly questioned whether the SEC had satisfied the rigorous standard of imperitable harm as well as all required factors of the TRO. In response, the SEC claimed even in the last 48 hours as of July 28th Defendants have closed additional bank accounts. Around 33 bank accounts had been closed. Further asserting that beyond what alleged in the SEC complaint, the TRO application, that the SEC had caught defendants dead to rights, discovering in real time the defendants were moving their money and assets and dissipating them. That proffer by the SEC was demonstrably false and misleading. There was no need for the TRO against defendants and relief for defendants. There were no bank account closures involving any of the defendants in July of 23, nor did the debt box counsel or relief defendants close any bank accounts in 23. As shown below, any decision to close accounts were made by the banks themselves in 21 and 22. Moreover, the defendants and relief defendants did not dissipate any assets of DLI. To be sure, because of regulatory uncertainty surrounding crypto assets in the United States, unlike many other crypto entities, DLI, the Debt Box Counsel, left the United States for the United Arab Emirates. But importantly, DLI moved its operations to UAE 14 months before the SEC made its ex parte application. Instead of attempting to understand defendants' complex set of legitimate operating businesses in the United States, the UAE, and Ghana, the SEC saw some hints of what it believed to be suspicious activity, assumed the worst without a full and fair investigation, and lumped together all 18 defendants in the complaint into one bucket of complicity. The SEC then shoehorned a false and misleading narrative to fit its desired story that the SEC is providing real-time enforcement of alleged crypto scofflaws. And this is why I say this has now become a war of words, a war of narrative between one of the best law firms in the nation in crypto against a very budding and up-and-coming law set of attorneys for the SEC. Now, there's some good attorneys on both sides. I'm not negating that. There's some with a lot of stuff under their belt, but there's some fresh ones here. And what we have here, I believe, is a battle between those attorneys. I'm not even sure anybody cares now on these teams about right and wrong. I think they're all out there to prove their own reputation to a certain degree. And that's not, I don't want that to come out as belittling. It's not. It's what attorneys do. A lot of the attorneys that work for the big law firm used to be SEC attorneys. So it does make sense. But I want to get right down to the point. Let me scroll down. This is 33 pages long. I'm going to get down, try to get through some of the rhetoric here and get right specifically to what these allegations are, because I think that's going to be the important one. Here's the arguments. The TRO should be dissolved and a new temporary receiver from Utah should be appointed. As the Supreme Court explains, an ex parte temporary restraining order should be restricted to serving the underlying purpose of preserving the status quo and presenting irreparable harm just so long as is necessary to hold a hearing and no longer. This is already going on, 4 months? July? So let's say at the end of July. So August, September, October, 3 months, 90 days. And according to the defendants, 300,000 licensees have seen 71% of the value of their business shattered because of what the SEC and the receiver has done. That's what they're pertaining. They say here, number 2, the SEC improperly obtained an ex parte by providing false and misleading information. This is where when and I've mentioned this in other videos, I don't see fraud on behalf of the defendants. The defendants are purporting now fraud by the SEC putting out false and misleading information. We talk about people in churches being hypocrites. It's definitely, you see both sides here trying to play each other off as hypocrites. So it says the ex parte should be dissolved because the SEC improperly obtained an emergency relief against the defendant contrary to the SEC's representation. There was no risk of immediate and irreparable harm. The SEC made 2 sweeping claims. Claim number 1, the SEC claimed defendants were in real time attempting to relocate asset and investors' funds overseas. even in the last 48 hours, I just read that. The fact, the SEC claim is baseless. There is no bank account closures involving the defendants. Even the SEC's accountant stated that there were no accounts that have been closed within the last 48 hours. And in fact, the debt box defendants and relief defendants themselves did not close any accounts in 2023. And the only other accounts that have been closed, all by banks, had been in 21 and 22. So to date, the defendants and relief defendants, former banks, have not advised them of why the exact reason they closed their accounts. Now, I'm going to tell you, some of this is behind the scenes, is what it is. It has nothing to do with the debt box. We know earlier this year, Signature Bank, which was a huge crypto bank, had gone down. The FDIC had to come in and take them over for whatever reason. Several other banks went down there for a while. We saw like 3 or 4 banks that went down. There's a lot of banks, I believe, that are saying, look, we're just going to get out of the crypto business. We're not going to be around it. We're going to have these guys close their account. I have several banks that I do business with. I've been in crypto since crypto was about $19, I think, a coin. So it's substantially higher than that. I have a small state bank that doesn't really, they don't understand crypto. They don't get it. I've got a national top tier bank, billions of dollars. They got no problem with crypto in, out. They understand it very well. They've got a whole team that focuses on cryptocurrency, blockchain, stuff like that. So you're going to see that. Claim number 2, the SEC claimed the debt box had stated that it is in the process of moving operations to the UAE. The fact, highly misleading. In public video that lasted for an hour, the SEC took just a snippet to use. And they go on to say basically that they'd moved the operations in 2022. They started talking about it in March. They moved the operations in 2023. So everything that's in the United States is a subsidiary of that business from what it sounds like here. So again, now it gets really convoluted because it's like who owns what, when and where. And that is a big one here that they're trying to dissolve. Said the SEC failed to make a clear showing of substantial likelihood of prevailing in its merits when the court provided the SEC a second chance to meet the required prongs. The SEC made the following claim. Even in the short time that the SEC has been investigating, we have affidavits verifying multiple instances where the key businesses underlining their operation were fraudulent. Now, they used 4 different declarations. The first one, the Watkins Declaration, is nothing more than a descriptive list of documents and videos that an SEC staff attorney searched and read or watched during the investigation in this matter. Carefully review the attorney's declaration, and it shows that Mr. Watson interviewed none of the other declarants. And notwithstanding his claim of personal knowledge, he lacks any personal, direct, or real-time knowledge of the underlying events. Basically, what they're saying there is he watched a bunch of videos. We watch a bunch of videos. So, I mean, that doesn't mean you understand it. Doesn't mean you understand crypto. Doesn't mean you understand their business. I'm going to tell you, as somebody that understands crypto, someone that understands marketing, someone that somewhat understands commodities, I didn't understand their business. I kept asking questions through the whole time that I ever found out about debt box. So, second, the Nardini Declaration, which contains the statements of CEO Nardini of Fleet Space Technology, also does not show the key businesses underlying the defendant's operations are fraudulent. So the declaration claims that Fleet and Brannon, on behalf of his company, RFEG, entered into an agreement. There was a press release that Fleet put out to it. And then Mining Magazine, they covered that story. It was a big story. What they're saying is, and if you see the complaint, the SEC saying, hey, Fleet says they're not doing business with you guys, and yet you guys are still saying you've got this technology. They actually did. Fleet got a little bit skittish because there was a lot of the IX Global people that represented Debt Box putting out videos that were just marketing hype. They were saying that Debt Box has this technology and all this stuff, and that is false. Straight up, it wasn't Debt Box that had the technology. They didn't own it. That was Fleet. That was a deal. And that's where you've got to have a good marketing team that works in tandem with a good compliance team to educate the field on what's best to say and what's not. And you don't allow other people to do videos. You don't allow them to talk about your comp plan. You don't do any of that. You handle that. Because when you don't, FTC or SEC is going to come hunting. Just the way it is. The declaration basically says, hey, the company was very quickly to get these videos down, straighten it up, but they decided to move on. The declaration, we also know from court filings that the debt box through, I believe it was Brannon's company, literally had all the technology. They'd already found a second source. You know, and some of the conspiracy theories that I've seen out there is people saying, well, the U.S. government wanted the technology, so they're taking down debt box. There is no technology that debt box has that anybody wants. It's all third party. And DebtBox had figured out a way, let's put this together. Now, where it gets really good is what they were doing with their blockchain. If they could pull that blockchain off, that was going to be really cool. That was going to be really good. If they could tokenize the assets like they were doing, make those profits, put those profits in, burn the coins, raise the price of the coins there, just like Ethereum's. That's great. There's nuances in this thing, you know, that I could say, you guys should have, from a marketing standpoint, changed things. But the complaint itself and what these guys are saying, it's going to be an interesting fight is what it's going to be. The third declarant, Johnson's, which is clocked full of inadmissible and irrelevant double hearsay, innuendos, and speculation, should have had no weight in the TRO. And basically what this says is that Mr. Johnson, who was an IX Global rep, consulted with his uncle, who had been a geologist, and then one of his other buddies, they talked to a couple of other guys that were in the drilling, and they all said, we think this is bogus. So they decided it was bogus. Literally, that's what it says in here. And this was part of what the SEC was using. This is why the defendants are upset about it, because that is not a municipal in court. The question that we don't know is that admissible when you're trying to get a TRO? Laws are a little bit different in certain situations. So again, this is why I say this is a play on words. This is a battle between the attorneys. And hopefully, you watching this, who probably own the software, one of the 300,000 who saw 71% of your value go down, hopefully you'll be able to see that recovered. Hopefully that if it is fraud, you'll get your money back, because the SEC's got a lot of assets that they can grab. There's over 110 million worth of money that went through this. There's a lot of assets that are still out there. This was, it really does, it's an ongoing business. There's oil wells that are owned here. There's a lot of stuff that is owned. The question is, where's the truth lie? A lot of facts from the SEC, a lot of facts from the defendant. Where's the truth? And that's why we cover these cases, along with telling you, be careful how you market. If you're marketing wrong, your company can go down. If you're allowing the reps to market wrong, your company can go down. If you're a rep and you're marketing it wrong, you can go to jail. So let's keep this thing right. In the last declaration, the Serena Declaration generally recounts a business relationship that went sour between Jason Anderson and Ryan Bowen and the Renegade Manufacturing Group. So that's where that was. These are four major declarations that the SEC relied on that was these guys are saying was bogus. And it said the SEC failed to show that the threatened injury outweighed the harm. And basically, even though the judge was reluctant, he signed off on it. Then, from my understanding, he recused himself, actually. Now, the last and most important one that I want to cover is the out-of-town temporary receiver should be removed for failing to manage the assets and failing to disclose the potential conflict of interest. In addition, the SEC in a sealed hearing requested the court grant the appointment of a temporary receiver from Florida in the matter instead of fairly serving mandates on this court as court-appointed receiver. The receiver has become a deputized agent of the SEC. Now, this is what they're saying. In the law, it says the SEC may present several receivers. They don't have to. It doesn't say it has to be an in-state receiver. Most of the time it is. For whatever reason, they picked the out-of-state receiver, the law firm from Florida, to take over management of the assets. To me, that's not smart either, because I would think, okay, if this company's all basically in Utah, then get a firm right there out of the valley in Utah and let them handle all this stuff. It's going to save on travel. It's going to save on long-term lodging, all that stuff. And they probably know other people. They're going to get some information out. I don't know why they did that, but this is one of the big ones. What did catch my attention on this, which is I think more important, is the potential conflict of interest. It seems like this attorney had done some work for one of the defendants. So that's pretty bad. Now they're claiming that he works for the SEC, that he's not working on behalf of basically the investors of the companies is what. So here's what they're purporting that he has not done. What makes this interesting is my next video, I'm going to show his report. Now you get the tit for tat. Okay, it's going to be interesting. But here we go. He removed key employees which could have continued to manage the ongoing businesses. He failed to make ordinary course expenses, which put the businesses in harm, put them probably in default in some stuff. Failed to secure the 4 oil drilling rigs that the company owns, and that's been verified they do. Failed to understand blockchain. Based on his own report, it seems that, but he said he demands imprudent transfer of crypto assets, is demanding defendants to withdraw all liquidity from trading pools in the secondary exchanges without realizing that such a withdrawal would amount to a rug pull. And let me explain this. When you've got tokens or coins that you've put out on exchanges, you've got to have a liquidity pool that helps to drive the price, or if somebody tries to bring the price down, you're going to buy the coins. The exchange isn't going to be the one that hurts that. It's kind of like having an escrow account is basically what it is. I've got several clients in the crypto business. I'm not the expert, but I've sure learned a lot on this. So I understand the need for the liquidity pools. That's just a given. Failed to respond to defendants' multiple requests for clawback agreements in which defendants would provide copies of potentially privileged documents of the defendants that the DL's former counsel may have produced at the request of the receiver. This is huge here. If this is true, it's an interesting one. Indeed, we respectfully submit that it appears the receiver is engaging in calculated efforts to extinguish defendants' legitimate operating businesses so that the receiver could somehow validate the SEC's incorrect view. That's what we're dealing with here. So in conclusion, it basically says this is the reasons we want this to be overturned. This is big. This is what we're watching, because this case, again, has gone down to how much of what the defendant's lawyers are purporting is relevant. Let's just use that word. How much of what the SEC said is relevant? Who's committing fraud or who's committing heresy? I mean, if you're here for the people, you need to be for the people. I don't know. But what I do know, and what I've pulled from this case so far, is D.E.B.T Counsel, IX Global, at best took their eye off the ball on some of the marketing that was there. And they allowed way too much to go on that they should have kept control of. You have to have a good compliance team. You need a good regulatory affairs team working in tandem with the marketing team. Communication will either break you or make you. That's the key. And if you will use a trust-inspired, purpose-driven communication that's really focused on serving those people that you say you care about, you're gonna be able to weather some of these storms. If you don't, you're gonna be screwed. So, hey, live life like it's an epic adventure. Stay dangerous, stay strong. And if you're in a home-based business, act like it.